Welcome to You and the Law. This is a program presented by the Chicago Bar Association. I'm Barry L. Gordon, a member of the Chicago Bar, and I have my own firm, Barry L. Gordon and Associates in Chicago, where I concentrate in family law, medical malpractice, and personal injury. A Department of Children and Family Services, we'll call it DCFS, investigator shows up at your doorstep. What do? Do you call a lawyer? Do you not call a lawyer? What rights does that investigator have, and can that investigator take the child from you if they suspect abuse or neglect or any other matter that would be abusing to the child? Does he or she have the authority, or does the police have the authority to take the child, or do both have the authority? Where's your child taken to? There is a DCFS hotline, which we'll mention in the show a little later on. Anyone can call if they suspect abuse, and they can report you. Doctors and teachers have a duty to call if they suspect abuse. There are guidelines that the DCF uses to follow if they suspect abuse, and what is their first and next step. The investigation is not criminal, but when you say anything to a police officer, that may be used against you in a criminal proceeding. How many days does the investigator have to complete their investigation? How soon should they make their investigation? We're very fortunate to have with us today to help answer some of these questions and go over the nuts and bolts of a DCFS investigation, the Chief Administrative Law Judge for the Illinois Department of Children and Family Services, Judge Sadzi Oliva. Thank you for coming on the show today.
Thank you, Barry, for having me.
It's a pleasure. And Judge, you hear appeals for the Department of Children and Family Services, and you make the appropriate decisions as to whether or not there's abuse or neglect and other problems affecting children. Is that correct?
That is correct.
Okay, in your processes, there's going to be an appellant, and that's the person that's appealing. Is that correct?
That's correct.
Okay, you've been a Chief Administrative Law Judge since May of 2014 to present, and you supervise a staff of 40 administrative law judges?
Yes.
And a staff that's charged with processing over 4,000 cases a year regarding expungements, licensings, and appeals.
That's correct.
You review recommendations sent to the director, you resolve personal matters, filling of vacancies, union grievances, employee disciplines, and evaluations, and so forth.
Yes.
You've been an arbitrator for Cook County Mandatory Arbitration since 2013 to present. And you have been an ethics officer for the Illinois Department of Financial and Professional Regulations.
Yep.
You're a graduate of Loyola University School of Law. You received your Juris Doctor there, and you've also graduated DePaul University. So let's start and see where we can go here and answer a lot of these questions. Someone calls DCFS and you are the individual, let's say the mother of a child. What would you do first?
Well, you probably want to obtain an attorney. However, if you cannot afford an attorney, we will not provide one for you. DCFS does not provide attorneys, but you may decide to represent yourself, which is called pro se, or you also may have an authorized representative follow the rules specified for authorized representatives and represent you in the matter.
Do you have handouts to help the people do this?
Yes, we have all of our rules and statutes online, and the appellants, if they're indicated for child abuse or neglect, receive their rights and responsibilities.
All right, and there is a hotline that people can call if they suspect abuse, and that number is 800-252-2873. And it's my understanding that doctors or teachers have a duty to call if there is abuse that they suspect?
Yes, there are mandated reporters, and those mandated reporters are required to report abuse, and as you said, doctors, teachers, members of the clergy, and other designated groups of people are known as mandated reporters.
Okay, and the person taking these calls on the hotline, they have certain guidelines to follow?
Yes.
Okay, and the next step would be that they would appoint a DCFS investigation?
If it is determined that there needs to be an investigation, yes, the matter will be referred to the investigations unit and an investigation will be opened.
And one of these investigators, they're called the Child Protection Investigator, is that right?
Yes.
Okay. Now, as I said in the opening, that it's not a criminal procedure, right?
That is correct. It is not a criminal procedure. It is an administrative procedure. However, there may also be a criminal matter pending at the same time related to the same facts, which may be handled by a law enforcement agency, the state's attorney's office. So there may be two different cases related on the same facts going on at the same time.
Now, is that when an investigator screens it to a state's attorney?
Yes, an investigator may screen it to a state's attorney, refer it to a state's attorney, yes.
And the state's attorney then would investigate the facts and see if they have a case and they have enough evidence to make it a juvenile case, which would be criminal.
Correct. And their burden and their way to go about their investigation is different from ours.
Yeah, in fact, your investigation, you don't follow the rules of evidence, is that right?
Well, we do follow the rules of evidence in an administrative procedure. They are lax, pursuant to the Illinois Administrative Procedure Act, but there are similar evidence gathering mechanisms that our investigators follow.
Okay. And since we said it's not criminal, can it be used against you, anything you say by a police department or a state's attorney in the juvenile case, anything you say in the DCFS investigation?
Well, DCFS investigators will not read an appellant or a suspected child abuser or perpetrator their Miranda rights because they're not required to do so. So it is a little bit different than when you're being interviewed by a police officer,
Okay.
yes.
Now, when a DCFS investigator is appointed, they have 48 hours to get out to the scene or the home and start their investigation, is that right?
The investigation, if it's determined that one is necessary after the hotline call, will begin within 24 hours.
24 hours, okay. And what do they usually do in the first 24 hours?
Well, first is child safety. A determination needs to be made whether the child is safe enough to remain in the home. And then it'll begin with the regular investigation, document gathering, interviewing witnesses, whether it's teachers or social workers at school or hospital personnel, the parents, relatives, anybody who may have been involved in this child's life, as well as perhaps issuing subpoenas.
I would think that the relatives would be very important people to interview. They are usually at the house more often than other people, and but they have a little built-in bias. Is that a fair statement to make?
Sure, that's a fair statement to make. You know, in any case, there are going to be witnesses that may be more biased than others, and that's the administrative law judge's job to see what their credibility is, what perhaps read into what their motives are, and that'll happen at the administrative hearing.
Okay. Now, at this investigation, if the investigator suspects that the abuse is ongoing and that the child is not safe in the home, what would the investigator do? What kind of offer would they make with the parent?
Well, if the child is in imminent risk of harm, the department can take temporary custody of the child, or the state's attorney's office can take temporary custody, as well as medical personnel.
Okay, so the investigator, him or herself, have the right to take the child. They don't have to call the police.
They could call the police. They could, yes.
Okay.
Especially but they may also take yes.
the child themselves. And if they took the child, do they not have to have a court order saying that they then have custody of that child temporarily?
Yes, there does eventually need to be a temporary custody determination order from a circuit court judge. However, the child's safety is the #1 determining factor, and then there's all these other set of guidelines as to what comes next.
Now, I hear a lot about a safety plan that the parent can enter into with the investigator.
Yes.
Tell us about that.
Well, as the administrative law judge, I can definitely speak to what happens in the administrative hearings unit. I do know that there is a safety plan. Again, it always centers around the best interest of the child and what that would be. It may be temporarily placing that child with a relative, or that's usually what the goal is.
Okay. And do you happen to know if that child is placed with the relative, do they need a court order giving that relative authority with the school that the child goes to or other agencies?
Yes, all of those things are determined once it is known that the child's safe, and then following the guidelines that DCFS has set out.
Okay, and I understand that this, quote, safety plan is put into writing so that both parties understand what their responsibilities are?
Yes.
All right, and DCFS at that time can, and if they wish, ask the state's attorney to investigate and see if it's proper to go to juvenile court.
Correct.
Okay, now, do you have to agree if you're a parent to a safety plan that's proposed by DCFS?
That's a good question that I am not sure about. It all, again, I think it goes back to the safety of the child, and if the child's risk outweighs what they're agreeing to, I'm not sure.
Yeah, okay, all right. Now, if you're charged with abusing a child or neglect, would you be able to get an attorney appointed for you?
No, the department will not appoint an attorney or pay for an attorney before DCFS proceedings. However, in criminal court, everybody is entitled, if they don't want to retain their own attorney or represent themselves, to a public defender, but the same does not apply at DCFS proceedings.
Okay. DCFS has a certain amount of days to complete their investigation. Is that a statement that's fair?
Yes, that is correct. DCFS investigators have 60 days to complete their investigation. However, there may be reasons to extend that deadline, perhaps 30 days. Maybe if the state's attorney's office asks for a delay, then the DCFS investigation may be given 30 additional days if there's good cause.
Now, if a mother of a child has a boyfriend living with her, and the boyfriend, let's say, slaps the child or commits some type of abuse, and it's basically not the mother's fault, would they ever just charge the boyfriend, or would they consider that the mother allowed it to happen, and therefore that's abuse?
They both could be indicated for child abuse. The mother perhaps for what's called inadequate supervision if she knew that this was taking place and did nothing about it, and definitely for the boyfriend that under the rule, the boyfriend or girlfriend or whoever is living there, it would be called the paramour. And for abuse cases, any paramour can also be considered.
Okay, and if DCFS accuses you of abuse, there is a DCFS database, is that right? Can you tell us about that?
That is correct. So once the investigation is completed and it is determined that child abuse took place, you are put on what's called the State Central Register. The State Central Register is the database of child abusers and child neglect perpetrators. That list is confidential and not available to the public. However, there are certain entities that do have access to that list, such as law enforcement, school personnel, that may need to look at a prospective employee's background, especially if it's in the child care industry.
And that could also include being a coach in a high school?
Exactly.
Anything that a sex predator would probably participate in, those type of agent, we'll say schools or programs where they show up.
Correct.
Okay, and that's why we have this database, is that right?
Yes.
Okay, now when we talk about custody, temporary custody, in a juvenile court, it's my understanding that the first hearing is about who is going to have temporary custody of the child.
Okay, that makes sense, yes.
Okay, and sometimes the allegations are so serious that if you were the accused person, you would want to enter into a safety plan of some sort.
Right.
Certainly would want your child to be with a relative as opposed to a juvenile agency.
Yes.
And let's talk about that. The state has certain agencies that they send these children to?
Yes, the state contracts with certain agencies that could take temporary custody if there's nobody else, but the goal is always to have a relative.
Okay. And it's my understanding, and maybe you could clarify it, that the agencies can make arrangements with certain people in the community to take the child on certain days and
Sure.
give them a home life as
And-
much as possible.
And the safety plan may include the biological parents who may or may not be involved in the case to visit these children on a supervised, very restricted basis.
Okay. And DCFS has the right sometimes to stay out of a juvenile process and put a hold on their case to see what happens in the juvenile court.
Right, so once the appeal is received and it is determined by the judge based on information given to the judge by either the appellant or the DCFS attorney that there is a pending criminal or juvenile matter, then the DCFS administrative proceeding will be dismissed until the time that the other case is resolved.
And that makes sense because you don't have two proceedings going on at the same time.
Right.
The same issues involved. Okay, now let's talk a little about the appellate process. And that's where you come in. And that's where you're an administrative judge. And this appeal process, it seems to me that any time I hear the word appeal, it's going to be a little complicated. We're dealing here with lay people. We're dealing with people who cannot afford an attorney. And has DCFS made it so that it is manageable by these people?
Yes, the Administrative Hearings Unit takes due process very seriously, and that's definitely one of our goals, as dealing with the parties and appellants. And when an appellant appears pro se, they can look up our rules, they can go online, they are given notice of exactly what they were charged with, what their rights and responsibilities are. When they first appear at their pre-hearing, they're notified of the date, the time, where it's going to take place. They're all done by phone, but who's going to call them, what time they're going to be called at. And while the administrative law judge handling the case cannot give them any legal advice, they know that they're pro se and they may not understand all of the legal terms, all of the legal processes, so they will guide them along the way procedurally.
Okay. And is there an expedited process in some of the cases?
Yes, in some of the cases, there is what's called an expedited appeal, and those are cases involving child care workers, teachers, bus drivers, nannies, maybe a nurse that deals with children every day at a hospital. If it's determined that the appellant is a child care worker, they may request an expedited appeal that needs to take place from beginning to end within 35 days. And that's because they have a property interest in their child care worker status. So we want to ensure the utmost due process. And there's also been consent decrees that DCFS has entered into, making sure that we meet those federal guidelines.
And I certainly can understand that because I have never been a teacher, but if I was a teacher of a first grade class or kindergarten, I probably would go a little nuts with all the jokes that they're probably going to be playing on me, the kids, and sometimes you can get really mad if you're a teacher.
Right, and if your employer finds out about it, which they most likely will be notified, it'll affect your livelihood.
Okay, so that's an expedited appeal.
Correct.
Now, the judges that work under you, they are given a file when the appeal process starts?
Right, they are given the assignment by our clerical staff, and the clerical staff handles the docket for the entire unit and for each administrative law judge. And all of our downstate pre-hearings take place on Mondays by phone, and then all of our Cook County and surrounding county cases, upstate Illinois, will take place on Tuesdays. And so on the day before that day of the pre-hearing, the administrative law judge assigned to that case will receive the file.
All right, do you have judges downstate, or do you?
Yes.
Okay.
We have judges throughout the entire state of Illinois.
All right, and do you provide interpreters?
Yes. And translators.
And
that,
translators.
Right, and that was part of another consent decree that DCFS entered into, that the appellant just needs to tell us what language they require an interpreter or translation for, and DCFS will provide one for them at no cost.
Okay, now when an appeal is filed by an individual, the appellant as we call it, and they send notice, I guess, to DCFS that they're filing an appeal, does the attorney for DCFS file an appearance?
The attorney for DCFS does file an appearance. The notice of the pre-hearing that goes to the appellant also goes to the DCFS legal supervisor, and that supervisor then will make the case assignment to an attorney, and that attorney will file an appearance.
Okay. Now, in cases of civil nature, civil cases, as we have in every state in the union, rules of evidence are followed, and we have discovery. Discovery process are tools that lawyers have that they can discover what's going on, how much money you make, they can discover where your bank accounts are, they can discover all these things that are pertinent to your particular case. And in fact, in Illinois, lawyers do have the right to issue their own subpoenas when a case is pending. Now, it's my understanding in the appellate process that you're talking about, there is no discovery.
Well, there is discovery. It is not as formal as in a civil proceeding, but the parties do exchange their witness list. So whoever they intend to call at the formal evidentiary hearing, they do exchange documents. The department will certainly turn over to the appellant the investigative file, any law enforcement records that were obtained in the process, any medical records that were obtained through the investigation, any interviews that were done of the child victim or anyone basically that was interviewed throughout the investigation. They will receive those. So there is a discovery process that needs to take place, but ultimately it's the administrative law judge who at the time of the formal hearing will decide what gets admitted into evidence.
Okay, now the appellant has 21 days after they make a request for a hearing, is that, and then a hearing is set?
Right, they make a request within 60 days of the notice of being indicated. They have 60 days to make a request for an appeal.
Okay, and that's called a pre-hearing?
The pre-hearing is the first day that the
hearing.
matter is up, yes.
Okay, what happens at the pre-hearing?
At the pre-hearing, the administrative law judge will call both parties. They'll call the appellant, call the department attorney, and the matter is recorded. Anything that happens between the parties is recorded and saved as part of the record of the appeal. And it's basically talking about procedure, introducing the case, introducing the parties, this is what's going to happen, and what's called a first offer date is given. That first offer date can only be accepted or rejected by the appellant in order for us to meet our federal timelines. And should the appellant not wish to go to hearing so soon, they may ask for a continuance, and then the timeline stops. It will not be counted against the process.
And so the appellant does not bring with their witnesses on the first hearing date?
No, on the first hearing date, it's just getting the actual formal hearing date set, and it's at the day of the actual formal evidentiary hearing that they come in person and bring their witnesses.
Now, they have to provide you, the appellant, with a list of their witnesses, correct?
Yes.
And I'd have to say, from your experience, most of them are usually relatives?
Relatives, friends, yes. On the appellants, yes.
Okay. In civil cases in Illinois, we're not allowed to tape or record evidence, but it's my understanding that you do not have court reporters in this administrative process, and it is recorded by a machine? It's
digitally recorded.
Digitally recorded?
Yes.
Okay. And you, as the administrative judge, you hear objections?
Right. So at the formal hearing, the administrative law judge will make rulings on any motions that may be presented throughout the hearing and objections.
Okay. And do you also cross-examine the relatives that appear or witnesses that appear on behalf of the appellant?
Yeah. So it's like a normal trial in civil court, a little bit lax on the rules of formality. There'll be an opening statement, cross-examination, direct examination. The department will rest, and then the appellant will present its case in chief, and then closing arguments.
Okay. What are you looking for as an appellate judge in this process when you hear this evidence, if I may ask?
Sure. Well, it depends on the case. The types of cases that the administrative law judge is hearing can range from death to inadequate supervision, sexual molestation, medical neglect. There are a number of allegations that they could be getting evidence for. And They're determining credibility. They're weighing the witness's credibility. They're determining how much weight they're going to give the evidence that's admitted. But they're making findings of fact, ultimately, and conclusions of law.
So some of the questions you would ask if it was, let's say, a relative, let's say an aunt, you would say, how often do you visit the house? When you come over, do you come over socially, or are you always picking up mom to take her grocery shopping? What are the reasons that you're over there, and how frequently are you there? Is that a fair question you would ask?
Yes.
Okay, so you want to see what the contact is between that relative and the child in question, and to see if the relative actually does have knowledge as to what's going on in that home.
Right, and the administrative law judge, once direct and cross-examination have taken place and they feel that they need more information, may certainly ask whatever questions they need to be able to make a finding of fact.
Now, many mothers have to work because they don't have anybody supporting them, and they're gone all day, and it's very difficult for them to find a place to place their young child who's not in school yet, or even the one that is in school when they get out of school. Do you find that this is a problem?
Those types of cases would fall under inadequate supervision, and it really is a case-by-case basis. Some of the factors include the age of the child, how long are they left alone, do they have access to someone they can run to, if something happens, or is the mother close by? There are so many determining factors in that type of case that it would be hard for me to give you one solid answer on it, but it definitely depends on the case.
Right. I just wanted the viewing audience out there to understand that everything's taken into consideration by you as a administrative judge, and you're looking to see the avenues and the decisions that are made by the, let's say, we use the word mother or the appellant.
Correct.
In these cases. Now, the notice of the final administrative decision, that's the decision that you make, has to be within a certain amount of days.
Right, so once the formal hearing takes place, the administrative law judge will be told by their staff how many days they now have to complete their recommendation and turn it in for review, and then subsequently to the director. So they usually don't have very much time depending on where they're at in those 90 days. So the judge will write what's called a recommendation, which includes findings of fact, conclusions of law, and their recommendation.
Okay, and it's my understanding that you, as the supervising administrative judge, have you review what took place by the judge who handled the case, or who heard the case, as the lawyers say, and you make sure that we'll say the verbiage is proper and that nothing is missing that should be there.
That is correct. We review, obviously, for typos. I review for clarity. The goal is for the reader to understand how the administrative law judge came up with the recommendation that they decided on. We will not ask an ALJ to change his or her opinion, just making sure I know why, so that then the director knows why, and any reviewing court knows why they made that decision.
So how many, well, let me say this, is any of these appellate hearings held in your office, or are they held in a courtroom? Where are they heard?
There are certain locations throughout the state of Illinois where the hearings take place. There is a hearings unit in Chicago at 17 North State, so most of the Cook County cases take place there, and there are designated hearing rooms for that, and then we have them throughout the state in Springfield as well.
Well, I think you've given us a certain amount of information, and I'm sure it's a very rewarding job for you, and I think possibly a sad one at the same time.
Exactly.
And I think that we've learned a lot today, and I want to thank you, Judge. It's been very informative, and I've learned a lot myself, and I think that's just been terrific. Thank you for joining us.
Thank you. It was great being here.
Thank you, and I want to thank the viewing audience for watching You and the Law. This is a program presented by the Chicago Bar Association.